not to dignify with an answer the erroneous allegations in the letter of Fortuna Narvasa. If there will be no motion, then it will be perceived and interpreted as no action will be taken to the answer of Fortuna Narvasa letter. If there are no other manifestations on the letter sent by the counsels of the respondent, we shall proceed to the next matter.
Mr. Chairman,
The Honorable Vice Chair Dumogan and then the Honorable Rodriguez. Rufus.
thank you, Madam Chair. What is important to me is notice had been sent to respondent in her counsel, and there is conclusive proof of receipt. Hence, this committee has complied with the element of due process. Unfortunate, that has already been said, she does not recognize the proceedings in this committee. Most important, you were duly notified of today's proceedings, but did not appear. Thank you, Madam Chair.
The Honorable Rufus Rodriguez.
Madam Chair, if I was so disappointed by the answer, consolidated answer ad coltelam, I am really totally dismayed by this letter sent by the lawyers. We have here 6 lawyers who has submitted a letter to the Honorable Chairperson, Jervil Luistro, that we have no jurisdiction to conduct this hearing, which they term as mini trial. Madam Chair, in the first page of the letter, March 24, 2026, it says, the Constitution vests the authority and power to conduct trial solely in the Senate. Clearly, what applies here is the constitutional provision that in the impeachment proceedings, we will have a hearing. It is not a trial. That is very much clear under our Constitution. They are citing here Section 3.8, Article 11 of the Constitution, the state shall have the sole power to try and decide all cases of impeachment. That is right. But we are governed not on the hearing by the Senate, but we are governed by the proceedings on impeaching to find out probable cause. Then, Madam Chair, in this letter, the second page, it says, the same, Article 3.2.11, the same does not give the committee any power or jurisdiction. Can you imagine that? How can they be able to support this allegation that the committee has no power or jurisdiction to conduct any form of trial, mini or full-blown, because precisely we are not having a trial here on the merits, but only, Madam Chair, on a hearing to determine probable cause. And then it also cites that it is basic that all rules must not contravene. We are not. The committee is not contravening the Constitution nor our rules or any law for that matter. And then finally it says, Madam Chair, that on the ground they're saying that we have no authority and jurisdiction on the ground that the committee and or the HOR as well as any of its members lack jurisdiction to conduct any form of trial or exercise of its incidents. Any law student would know that precisely our committee has the power to hear on finding probable cause by the 2 complaints where we found sufficiency in form, substance, and grounds. Therefore, I move that we issue an order traversing these particular erroneous allegations in this letter. Erroneous because they are the ones contravening the Constitution. The lawyers of the Vice President are the ones contravening our rules of impeachment. But then, in that letter, we invite them again to appear in the next hearing because we are always mindful of giving due process. So move, Mr. Chairman. Let us answer this by this committee.
Second,
We should answer that these are all erroneous and is not in compliance, is against the Constitution itself, which they are citing. And then be giving them due process. I am disappointed, Madam Chair. This is the chance of the Vice President. In their answer, they did not put forth. I thought it was a strategy that in the hearing, they'll be able to appear although, Madam Chair, I don't agree that we should have the Vice President appear here, but counsel should appear and be able to traverse all the 6 grounds of the 3rd complaint and the 5 grounds of the 5th complaint. So I move that we issue an order traversing this, saying that these are all erroneous and that they, in spite of their erroneous interpretation of the Constitution, they are invited to the next hearing if they so mind, because it's clear, our ground rules are clear, the lawyers are
May
able
we
to...
be clarified on
Yes.
the purpose of your motion of inviting the lawyers in relation to the letter that they sent to us?
Also that, and probably, but no, Madam Chair, very clearly, the letter has no basis in in law, on the Constitution, and our rules. We don't have to let them here to explain. I'm saying that we should be able to tell the lawyers that this is really a scrap of paper that they have submitted to this honorable committee. It's an insult to the committee if this is what they want. And so therefore, we have an order from the committee for them to tell them that they are wrong and that they are invited in the next hearing so that we continue to try to give due process to the Vice President, which we wanted precisely to have her side on these grounds. Thank you.
Your
So moved,
motion,
Madam Chair.
Honorable Rodriguez, is to invite the lawyers to answer to the committee about the erroneous impression that they're giving about the proceeding of the Justice Committee. Is that your motion?
No, not anymore. They have already stated this. What I'm saying is that we have an order denying this manifestation and putting our reasons why their letter dated March 24 has no basis in the Constitution, the rules, and the law. And then at the same time, invite them to attend the next hearing so that if they're minded,
We are
So same
inviting the
Yeah.
parties and the councils every time we have a hearing.
Chair. But in this case, they are saying that they do not recognize our jurisdiction. And so we're telling them that please come and recognize it because your premises here is totally unfounded and baseless. Thank you.
Right. So there is a motion to issue
Madam
an
Chair.
order
Madam Chair.
or an answer to the letter belying all the erroneous allegations contained in the letter of Fortuna Narvasa. Do I hear a second?
Madam Chair,
amendment.
it is not, we do not answer. We order. So it will not be, the committee will not answering anybody.
Yeah, yeah.
It will be an order because we have the jurisdiction to order by stating that they have no basis and they are invited to appear. Thank you,
Madam
but
Chair,
it depends on
There
the
is
chair.
a motion to issue an order to the councils of the respondent to attend in our subsequent hearings because all their allegations are erroneous. I am
Amendment to
pertaining to the
motion.
letter sent by Fortuna Narvasa.
Amendment to the motion, Madam Chair.
The Honorable DS Puno is recognized.
Yes, may I recommend that in the in the amendment that we state that this matter was discussed at this hearing and found to be defective and erroneous. So I think that those statements of Representative Rodriguez should be included in the order, and then the invitation. But I think we should make it clear that it was discussed, just so that it's not made to seem later on that it was dismissed without due deliberation here.
Madam Chair, may I?
Is
just,
this in relation
yeah,
also to
yeah.
the motion? The Honorable Zia
Yeah,
Alonto
before-
Adjong.
before we act on the motion, Madam Chair, just for the public consumption, because our kababayans are watching us right now, the order as proposed by Congressman Rufus Rodriguez should not be taken as something for this committee to treat the lawyers with an equal footing, because the legitimacy of this process does not rely on the acceptance or recognition of these lawyers or anyone for that matter. We are exercising our constitutional duty to proceed with the investigation, with the hearing as we are conducting right now. Para po sa kaalaman ng karamihan, yung sinasabi po ni Congressman Rufus Rodriguez is not really in response to put them in the equal footing as though the lawyers and this committee is exchanging ideas or opinions. Because number one, hindi po nakasalalay ang integridad ang proseso at legitimacy ng hearing na ito sa acknowledgement, recognition ng sino man o kanino mang parte, Madam Speaker.
Madam Chair, the letter was submitted
The Honorable DS Puno.
to the chairperson as chairman
It
of
is
the
addressed to the
addressed to the
chairperson, DS
chairperson
Puno.
as chairperson of the committee.
That's correct.
So I think at the very least we should manifest that this has been brought out to the members. It has been read by Representative Ridon, and it has been commented upon by Congressman Rufus Rodriguez. That does not make them and give them equal status with us. It merely tells them that we are fair, and we have taken this into consideration and actually found their manifestations and their letter to be effective in substance, no, in what
Madam
they
Chair.
allege.
Madam Chair.
The Honorable Jokno.
Yes, I have some serious reservations about using the term order because it could be twisted and made to appear that we are acting like a court. I would agree that we should respond to the letter since it was addressed to the chair. Perhaps the chair could synthesize all of the discussions made today. And if I may add on that point, we are exercising a constitutional duty today and in succeeding hearings to conduct a hearing. And we have gone through all of the form and substance. We have already made the finding that there's sufficient ground to proceed with the impeachment proceedings. So what else do we have to do except to look at the evidence? Yan po yung tungkulin natin. And it was be clear to the public and to the lawyers of the Vice President that that is what we are doing today. Thank you.
So the
Madam Chair.
suggestion of the Honorable Jokno is instead of an order of the committee, that the chairperson answer the letter of Fortuna Vasa. Let's hear the comment of the proponent, the Honorable Rodriguez.
Madam Chair, the issue has been brought to the committee. It's not anymore the letter is addressed to you, but precisely the issue has been discussed by the committee proper. And so it therefore should be an order, not a singular letter from the chairman, so that it is clear that that is the position of the committee, that we're ordering that they appear and that we are saying in that order that all their allegations, all their statements here are erroneous, have no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
Any other comment from the Honorable Jokno? Are you now amenable to the original motion of the Honorable Rodriguez?
I'm very concerned, Madam Chair, with the use of the word order because I anticipate that the councils, based on what I read in this letter, it would appear that they are looking for reasons to question the committee before the courts. And if we use that term, they can use it against us and say, see, you earlier you mentioned mini trial, now you are ordering us. And that will, then they can use that as a ground for questioning the committee. In fact, Madam Chair, they are entitled to their own opinion about what we are doing today. If they believe that we don't have jurisdiction, that's up to them. But I believe that we must just do our duty, fulfill what the Constitution commands, and hayaan na natin sila kung yan ang gusto nilang opinion. It's very clear from our discussion that we are not doing what they claim we are doing, that we are not going outside the jurisdiction, but rather following what the Constitution provides.
Chair, final point, Madam Chair.
To resolve the disparity between the motion of the Honorable Rodriguez and the suggestion of the Honorable Jokno, may we just release a letter in response to the letter of Fortuna Basa from the Justice Committee and not from the chairperson of the Justice Committee, if that would be acceptable to these two gentlemen.
First of all, just 2 points. First point, even in preliminary investigations, the prosecution orders clarificatory questions. Order does not mean that it will only come from the court or from the trial, the Senate, for example. Order is because we have jurisdiction. There is an order issued in preliminary investigation under the rules on criminal procedure that precisely order for there to appear to answer clarificatory questions by the prosecution. And so that fear of an order not being, it will cause some, comments from the other party. It's not to me, it's not very, at this point, it's not something that we cannot do. We have to therefore emphasize that as Committee on Justice is hearing. We are not having trials, but we are hearing for probable cause. And because they have sent this letter, which we find to be that they are not going to appear anymore because of no jurisdiction, an order requiring them to appear by stating also that their basis for not appearing, not recognizing the jurisdiction of this court has no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
I
Madam Chair.
understand that the argument of Honorable Jokno is predicated from the fact that we're being framed to be conducting a trial, when in fact this is just a clarificatory hearing. So for purposes of caution, no, in order not to give them any opportunity to place us in a wrong impression of not following the Constitution and the rules, I don't see anything wrong about answering instead of issuing an order, if that will be acceptable to the Honorable Rodriguez.
Madam Chair.
The Committee on Justice can respond to the letter in its capacity as the committee and not me as the chairperson.
Madam Chair, I always agree with the chair. Thank you.
Madam Chair. Madam
Same
Chair.
manifestation, Madam Chair. We agree.
Madam Chair.
Madam
The
Chair.
Honorable
Madam Chair.
Tino.
Well,
Madam,
sumasang-ayon po ako sa naging resolusyon dun sa
And that is the
particular-
letter of the Justice Committee.
Oo, particular dun sa hindi
Responding
nagagamitin ng...
point by point the erroneous allegations in the letter of Fortuna Narvasa.
Opo, na hindi nagagamitin yung salitang order, magpapadala ng sulat. Pero malinaw din po sa rules para lang i-put also on the record that the committee, according to the rules of procedure, that the committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. So just for the record, meron pa rin namang kapangyarihan
That is correct.
na mag-issue ng mga order, compulsory orders,
is correct.
ang committee ito. Yun lang po,
Just
Madam
because
Chair.
this is a formal proceeding, may I solicit the necessary motion pertaining to the answer
Chair.
which the committee will release in response to the Fortuna Narvasa letter?
Madam Chair,
Madam Chair. Madam
I
Chair.
defer to the position already expressed by the Honorable Chair with respect to just responding through a letter. But actually, my personal view is that we need not dignify that letter from the lawyer of
That's
the
another
respondent.
concern.
Yes, let's not dignify that. They're expressing their own position. It's not yet, it has to do, we can ignore that because it's wrong. It's erroneous. The position raised there is erroneous. And until and unless they really formally raise the matter, they formally raise the issue before this committee, then we need not rule on it. We need not issue anything. But I defer again. I defer to the position of the Honorable Chair and agreeing with the proposal of the Honorable Chair Jokno that we can only respond through a letter containing our arguments, our counter-arguments on the position expressed in that letter. But as I said, we can actually ignore that and let's not dignify that. Thank
To
you.
finally resolve our proper action in relation to the letter of Fortuna Narvasa, may I hear the necessary motion on the letter which the Committee on Justice will issue? If you are not in favor to answering that letter, then perhaps you should not vote in favor of this motion. Because Honorable De Lima is now arguing that we should not dignify with an answer the letter containing erroneous allegations about the jurisdiction of the Justice Committee.
Madam Chair.
The Honorable
Yeah, Madam
Adjong.
Chair, I was earlier, I was actually eager to second the motion of Congressman Rufus Rodriguez. But upon hearing the observation and the recommendation of Congresswoman De Lima, I think that would be much proper because earlier, Madam Chair, I was actually explaining to the committee that we should not give them any chance of maybe, attributing we're on the same standing or the same footing because this hearing does not rely on the acknowledgement or recognition of the lawyers from the law firm. So I guess it would be proper, I think so, for my own humble opinion, that we should not, again, if I may also use the statements of Congressman De Lima, dignify, and instead exercise this committee's mandate, because we also have the options to either making them order as cited. Pwede tayo mag-issue ng mga orders pala, as cited by Congressman Tino. So I think it would be much proper because we can still, maintain the integrity of this committee by simply not giving too much attention to their to the position of this law firm. So
For the guidance-
I would suggest that we take consideration of the suggestion of Congresswoman De Lima not to dignify this letter.
For the guidance of the justice members, our parliamentary status, there was a motion to issue an order. The same has been withdrawn by the proponent, the Honorable Rodriguez, by his conformity to the chairperson. Now there is a pending suggestion about issuing a letter from the committee to address the erroneous allegations in the letter of Fortuna Narvasa. But we are hearing another opinion not to dignify with an answer the erroneous allegations in the letter of Fortuna Narvasa. If there will be no motion, then it will be perceived and interpreted as no action will be taken to the answer of Fortuna Narvasa letter. Therefore, the chair announces that the
Madam Chair,
committee will not take any action to the letter. Let it be, so long as we are following the Constitution and the rules of impeachment of the House of Representatives. So ruled.